Assalamualaikum warahmatullahi wabarakatuh and good day. So today we're going to continue with part 2 of our discussion for chapter 5 for government liabilities. So we are going to talk we're going to look into government liabilities in tort. Alright, the first foremost question that people will always be asking is how can a government be said to have committed a tort? Because a tort is a form of a civil wrong, and usually it arises from a breach of duty fixed by law towards persons individually generally. So its breach is redressable by an action for unliquidated damages, and examples of tort can be in the form of negligence, nuisance, trespass and defamation. So again, the same issues arises. How is it that we can consider government to be committing a tort? So let's have a look at an example given here in the textbook. In the situation here, when we talk about Thor and Huck, okay, they were walking on the highway bridge, which was under construction, and that bridge was actually constructed under the instruction of the government. It is a government project. So let's say if suddenly the bridge collapsed and both Thor and Huck were injured because of the collapse, so both of them could actually claim against the government if they could prove certain conditions. So these conditions are provided by the Government Proceedings Act 1956. So they have to prove the provisions, the conditions in the provisions of the Act before a case can be brought against the government for any form of tort. Alright, under the Government Proceedings Act, Section 5 provided that the government will be liable for any wrongful act done or any neglect or default committed by any public officer if it can be proven that the officer is a government officer, and 2, the officer acted in good faith and were acting under the orders or instructions of the government. Under Section 6, subsection 1, before any action can be brought against the government, the neglect or default by the officer would have had lain against such officer personally. In other words, the plaintiff must be able to recognize which one of the officer actually commits the neglect or default. We can see from one of the case here, Muhammad Noor Effendi. In this case, an accident occurred whereby the defendant hit the plaintiff while he was driving the government's lorry, and he collided with the plaintiff. The plaintiff was riding his motorbike. So the plaintiff also could prove that it was the second defendant, the Malaysian government, was the registered owner of the lorry driven by the first defendant. So the first defendant is the lorry driver, and the second defendant is the owner of the lorry driven by the by the first defendant. Under Section 6, subsection 2, a specific exception was given. If, let's say, there's any written law negatives or limits the liability of the officer in respect of any act, neglect or default committed by him, then to that extent the liability of the government is also limited. We have a case of Zahara here against government of Malaysia. A claim was made by the plaintiff, that is Ms. Zahara here, for compensation for her husband's death due to the negligence of the armed forces during their emergency period. The husband of Madam Zahara here was shot after there was no answer given when they asked the victim to identify himself. So they thought that he was the enemy, so the armed forces shot him. So the government invoked Section 5 of the Emergency Ordinance 1969, which required proof of 2 ingredients: that the act was done in good faith and in reasonable belief that it was necessary for the purpose to be served thereby. So in this case, the argument was there is a specific law that allows them to act in such a way. So they wanted to negate, or they want to limit their liability in terms of what happened in that case. So they're using Emergency Ordinance 1969. Okay. Other than that, Section 6, Subsection 3 mentioned that no action can be brought against the government for any acts done or omitted to be done by a person exercising a judicial function, like tata tertib and all those. And then Section 6, Subsection 4 said the government is not liable for any act, neglect or default of an officer unless he was employed by the government and paid in respect of his duties as an officer wholly out of the government revenues. So they wanted to exclude people who is like part-timers or contracts or under contracts and stuff like that. Section 7, Subsection 1 further mentioned that no proceedings are to lie against the government according to anything done or omitted to be done by the government or any public officer in respect of the public duties of the government. But there is an exception to that lah. So what are the examples of public duties? So this one lah. Jadi contoh kita tengok case Tort and hak kan. Construction, maintenance of railways, schools, channels, river waterways and all this under Section 7 Subsection 2. So general rule dia, kita tidak membenarkan any action against the government kalau it is for public duties or for public in the exercise of the public duties for the public. However, under Section 7 Subsection 3, they said that a party may sue for damages or compensation arising out of negligence or trespass in the execution of any works of construction or maintenance undertaken by the government in the exercise of its public duty. So similarly here we have a case, an example, an illustration. Let's say while constructing a hospital, a government quantity surveyor instructed the contractor to use low quality cement, which consequently caused the floor of the building to collapse, injuring some of the building workers. So an action can be taken against the government because the injury was caused by an act of a government officer in the exercise of a public duty. Right. So under Section 22, it is also said that if you wish to sue the government, the state government, you must file the suit against the state government and not only against any individual party. So we have 2 to 3 cases to reflect on action brought against the government in regards to for torts cases. Let's have a look at one of them. Muhammad Raihan, in this case, an action was brought against the government for an injury sustained by the pupil during a practical gardening class. It used back then, we do have gardening class in school. Nowadays, we no longer have that. So what happened in this case? Dia terkena cangkul, tak silap, yes. So the appellant contended that the respondent failed to provide proper supervision, causing the student to be injured while they are using the cangkul. So the federal court allowed the appeal of the appellant, saying that even though it accepted the fact that the appellant was negligent, so the appellant in this case is the teacher. So the government is the respondent lah. So the federal court allowed the appeal of the appellant, saying that even though the appellant was negligent, the respondent failed to give proper instruction as to the use of agricultural tools. So the court also concluded the respondent failed to take all reasonable and proper steps to prevent the appellant under their care from sustaining the injury, and the teacher did not check the condition of the garden tools or provide a safe system of holding the gardening class. So I'm not sure whether that is one of the reasons why we stopped having practical gardening class after that, because the government lost the case at the time. Okay, in another case, government of Malaysia against Jomani. In this case, involves injury caused by a student using a pencil. So some commotion, a very naughty boy used to prick the thigh of the friends, and then suddenly in this incident, the friend turned his face towards him and the pencil poked his eye. So they had to remove the eye because of the injury. So initially, the teacher was found liable for negligence. Actually, damages was actually granted by the court. However, for this particular case, it was brought to appeal, and during appeal, the federal court decided that the teacher was not negligent because it is highly unforeseeable for her to expect the pencil to actually cause such an injury to the other pupil in the class. So these are some of the issues brought against the government, because teachers are actually civil servants. So usually what they do, they will sue the teacher along with the government as the defendant. Alright, so that is a bit on our discussion for government liabilities for tort.